Welcome everybody. I'm Jeff Ernst. I'll be your host today for Orangetree's first quarter 2021 compliance update. We are excited that you're here with us today, so we will just start getting right to it. I want to let everyone know that we do have a handout. It's in the webinar control panel. If you don't find it, just let us know. Send us a question. We'll make sure that you get that handout. We'll also have a replay available. We'll send an email shortly after today's call. So if you want to listen to the content again, share it with colleagues, you'll be able to do so, both the webinar as well as the handouts. On this particular topic, compliance, it's not uncommon for us to get a question, and we want to do our best to answer it for you, but it may be one where some of the particulars of the answer and continuing dialogue may be a bit more private in nature, so we may just defer that to an ensuing conversation, so just keep that in mind. And then regarding questions, you can submit those into the panel throughout the course of the webinar. We expect to have a few minutes at the end to be able to cover those. If for some reason, any reason, we just run out of time or can't get to your question, we'd be delighted, and we'll follow up with you with the email that you registered for today's webinar with. So welcome, and thank you for joining us today. At Orangetree, our promise to our clients is that we will deliver and design a background screening program in your best interest. Our goal is to become and be considered your teammate and trusted partner. Orangetree is a full-service background screening provider. We have international capabilities, and we offer all of the criminal verification, health, drug testing services that you would expect from a full-service background screening provider. We have three pillars of enabling that capability, three things that you've told us over the course of time that matter to you, and that is technology that you absolutely have to have to get your job done. Compliance, everything needs to be done right, and then client care that you deserve. And we've been providing this no compromise business approach for over 31 years. It yields great benefits for you because that's what it's all about. And that is primarily turnaround time. There isn't anyone on this call today that doesn't care first and foremost about turnaround time. There's other factors, of course, but you want to know that the background check, the final step in the pre-hiring process, or the pre-employment process, if you will, is completed as quickly as possible. And we are absolutely focused on that as well. You can see that 95% of our criminal checks are returned in less than 2 hours. Also, part of that turnaround time is customer service. You don't want to have to make a trade-off. You want great technology, you want great turnaround time, and you want someone there when you need help. And our client care specialists are there for you. And we provide 90% first contact resolution. And finally, from a candidate experience perspective, everything has to be fast and easy. And you'll see a screenshot a bit later on of our Candidate Connect, our mobile portal technology. And candidates voluntarily fill out surveys and rated our technology in their experience with Orangetree very highly. A bit more about our technology and some of the benefits that it enables for you. And at the core, again, is that turnaround time. And just an additional detail, not only are 95% of our criminal checks returned in less than 2 hours, but there are about 45% of those that are returned in minutes. And that really is a paramount and tantamount to the technology that we have built in place. We have our own technology team, our own platform, and so there are a lot of things that we have done utilizing technology innovation on the back end to ensure that we can get to the data that you need to complete your background check. Also enables great client care. Our client care specialists field a number of calls across a variety of aspects of our business, your background check. And while they see everyone and are accountable to every one of those back to you, we do have a team that supports them in getting you the information that you need. And so we've developed technology over the course of time to enable workflow to get to the right specialist as fast as possible and then back to you again. Our system is highly configurable. Our clients love that because they start with a set of needs. The business evolves over the course of time, and we're able to meet them where they're at today, as well as where they're going in the future. And of course, ATS integrations are paramount, and we have all of the top integrations covered. Our client care, we are here when you need us. By and large, you just want to submit the background check and you want it back and really no questions asked. And that's our goal and our objective and everything that we are focused on to help you enable that. But you do have questions. You do have evolution of your policy. You need packages updated. You have change in your personnel, individuals who join your staff who need some training, not only as we onboard, but also in the future. And our client care team is here to help you. They're responsive and also knowledgeable. All of our client care individuals achieve and maintain, and it's completely supported by the business, a PBSA FCRA certified credential throughout their tenure here at Orangetree. A little bit more on client training. It's available as part of the onboarding process, never a fee from Orangetree. And it's also available to you at whatever intervals that you need. You may need a refresher, you may add somebody, they may need a one-on-one sort of course or instruction set. We're delighted to do that. That is led by our dedicated client care specialist. And new, something that we have been rolling out here over the last couple of months, is a digital training library. I invite you to click on the PDF. There's actually an active link. It'll take you to a page and you can take a look at some of the work that we've done. So maybe you're working after hours, you're trying to get a refresher on something, or someone joins and they just prefer a digital format. They can click on these wonderful videos and learn how to interact with our systems. So a lot are already there and more to come. Client communications, the process with Orangetree just starts once you guys make a choice to work with us. We hold, as you know here today, webinars every month, the last Thursday, and then on a regular basis, we communicate with our clients, including a Tuesday Insights communication, kind of a wrap up on what's going on, some of the important things in the market. We publish a blog every Wednesday, which is really heavy on education, ensuring that you know not only this from the background screening, but some of the points of view and capabilities of what we're doing to impact that in a positive way. And really in the last year, almost it seems like we're out of this, but we're not quite. But the whole court closures due to the COVID situation, we have maintained an updated file, or it's on the homepage of our website, and we update that daily, something that's available to you. And we send out other communications as they are pertinent. Our whole goal is to keep you in the know with what you're trying to achieve with your background screening program at Orangetree. Last topic, candidate experience. We support your candidate. Your candidate can call. In fact, we really expect them to call us if there are questions during the background check. Never a fee. I heard the other day from a client that another vendor, competitor of ours in the market, was charging for access to a national drug hotline. That's too bad. If they'd used Orangetree, they would have saved some money in the process. But nonetheless, we don't charge for that support. We work with your candidates because we recognize that you have a job to do, and that is to fill open positions. And so we do the work of the background check so you don't have to. And we have some exciting things I'll cover here on the next page. If this is of interest to you, we have some capabilities that clients ask. We're delighted to provide this service. Could we put together a collateral piece, a handout, a landing page, whatever you might have in mind? We now have a facts page on our website available for your candidates. It's been amazingly popular with the candidates, really helps them out in their experience through the process. So if there's something you have in mind that you think might help you enable your candidates to have a better experience in the background screening process, reach out to your client care specialist. We're here to help you get what you need and get your candidate through the process. Just a splash screen of our Candidate Connect tool. And as you can see, highly customizable, very friendly, very easy to use. And again, the whole capability to contact Orangetree for help. So a button in your handout, if you'd like to contact us, or some of this new information for our existing clients, feel free to click on that orange button there, and someone at Orangetree will hop on a phone call with you and talk to you about your needs. Contact your client care specialist directly, or if you're new to Orangetree and like some of the things that you're hearing, we'd love to hear more. We'd enjoy the opportunity to talk with you and see if maybe there are some of the things that we're trying to accomplish here and bring to the table would fit your background screening needs. So without any further ado, I'll turn it over to our keynote speaker today, Heidi Seaton, who is our VP of Legal and Compliance. Heidi has vast experience in the background screening industry, as a tenured employee here at Orangetree, And Heidi, I will turn it over to you, and in a second, I will try to ensure I can get the controls over to you. And Renew, if I'm not seeing it, maybe you can help. Oh, here we go. All right, Heidi, the controls should be yours, so take it away.
Okay, I think I have it, and I think I'm unmuted, so that would be two major criteria met. Thank you, Jeff. I do like to throw up this disclaimer screen here just to remind everyone. I love to talk about background screening compliance and what's new and interesting, what we're seeing happening in the industry, what we're seeing happening in legislation, but it is important for everyone to remember, I'm not your attorney, I'm not giving you legal advice. And if you have, specific questions about your situation, or if you're wondering how to apply any of these state laws or regulations to your policy or program, I just do encourage you to seek the advice of your own legal counsel. That said, the introduction that's supposed to go along with the disclaimer on this page, as Jeff mentioned, I've been in background screening now for, I think we might be closing in on 20 some years here at Orangetree for about 11 years. For those of you that I talk to every quarter, welcome back. Some of you might be new. In general, these are the topics that usually get covered with some mixing up as we see things change over time. But we are going to spend just a little bit of time talking about COVID and how that's impacting background screening today. It's been a long year plus, and we are seeing some positive signs from a background screening standpoint. So we'll talk through those. Had just a ton of action around Ban the Box at the end of last year with state legislators. At the beginning of this year, so far this year, we've had a few. Some of them are significant, and very often they're going along with decriminalization efforts. We'll see, and we'll talk about that. I have a number of drug testing updates, lots of voter initiatives that happened at the end of the year. So they were sort of in the works last time. We got together, which was in November, but a lot of them subsequently passed or had some actions. So we'll talk through those. We have a few other background screening topics, specifically around Fair Credit Reporting Act, litigation, class action, and a Supreme Court case that we're watching. So that's my plan. I'm kind of going to launch right into it. Jeff had mentioned we do keep an updated document on our website talking about what's happening day to day with COVID-19. But in general, we are seeing, we were earlier in the COVID-19 era seeing courts being closed, sometimes for days at a time, sometimes for weeks at a time. We're seeing that declining. So that sort of rolling court closures that was happening, where we wouldn't know when they were likely to reopen, or there was no plan necessarily for reopening. We're seeing things getting a little bit better there. When we do see courts closing, it's usually due to a local outbreak or uptick, and sometimes specifically something that's happened within the courts themselves. So maybe there's some transmission or some report, something going on within the courthouse, and so we'll see specific courts closing. But generally, we're seeing those happen much less frequently. I would say if we are experiencing slowness, they tend to be especially impactful in those jurisdictions that are either clerk required or clerk assisted. So when I say that, I just mean maybe there's no public access terminal that our researcher can go to do their research. Maybe they actually have to go talk to a clerk, have the clerk do the search itself, or perhaps just have the clerk do a de-archive of a possible record. I would say when there's a COVID impact, those jurisdictions that have a clerk required or clerk assisted process seems like they're most significantly impacted. So for instance, in California, where a lot of those jurisdictions do require clerk interaction, sometimes the ETAs we're getting from those clerks are outrageous. still. Also clerk assisted in Michigan. So again, sometimes we're seeing delays there, especially following a closure, right? Because they're trying to get in, get staffed, and get caught up in their research. Kentucky, I would say, continues to be perhaps the most problematic of the jurisdictions. They have state guidance around when particular courts can reopen based on positivity rate requirements for reopening in that locality. So I would say that situation has certainly improved over the last quarter even, but still a bit of a bugaboo, and we are still sometimes using a statewide court search there as an alternate when things go too long. On positive news, early in COVID, we were seeing delays for verification services, so contacting employers, contacting schools, waiting for responses from schools and employers because they simply were closed. They simply were not staffed to respond to our verification requests. I would say when I checked in earlier this week with our team, our verification success rates have really returned to a pre-COVID state. So that's good news. That means when we're reaching out to employers and schools, we're talking to them, they have staff, they're responding at least fairly timely. So good outcomes there. And I threw this last bullet point on. We do get asked about if we can help or if we have a product for COVID-19 testing or tracking. What we're finding right now in the market, there's just a ton of pressure for all that testing, or at least early there was a ton of pressure for all that testing to be happening at major clinics and retail chains. That has happened. Very often you can go to Walgreens or CVS, get a test for free. Testing is generally now widely available, and we sort of expect it to remain so. It seems likely then, by the way, having gone through that whole process of creating a way for people to get tested, we're seeing that those same chains are in the front line for vaccinations. So that's sort of what we're seeing in the market for testing and tracking so far. Is that those major clinics and retail chains are leading those efforts. One note I forgot to mention on the very first bullet point around court closures. We were concerned early in COVID, we were hearing a lot about concerns about courts not keeping records up to date because of staffing issues. I will just say generally, lately, when we hear about court delays from candidates, so people who have a criminal record and they're concerned about it, it's not that the court information we're reporting is wrong or outdated. Rather, what we're hearing from that individual is a lot of frustration or concern about delays in the adjudication process. So for instance, where the defendant and the prosecutor have agreed to something, maybe they've agreed to a downgrade, they've agreed to a pretrial program, but they've not been able to get a judge to rule on those sorts of things because of scheduling issues or court closures. So an interesting take on where we thought we would be with court information, and I just wanted to share it with you guys, as that's what we're hearing around COVID-19. Moving on, right into ban the box, fair chance, decriminalization. Have to start with California. I really struggled with what order to put things in because I wanted to give updates on some of the ban the box, decriminalization, fair chance legislation and regulation that we talked about last time in November. Was sort of, it was something we were watching, or it was something that had maybe passed a legislature but was pending governor's signature or something like that. And so I did think about doing all of those first and then coming back, and then I just decided it was too confusing. Alphabetical it is, but unfortunately that means we start with California. So you maybe remember, you're hopefully aware, especially if you have employees in California or if you have locations in California, there was a Fair Chance Act from 2018 that had prohibited employers from asking about criminal record information before that conditional offer. And then also employers couldn't consider arrests that didn't follow conviction, pretrial programs, dismissed, sealed, eradicated, expunged cases. Again, that was sort of uncontroversial because generally employers don't consider that stuff. And it was applicable to public or private employers with 5 or more employees. Well, the agency that regulates that Fair Chance Act, that's the Department of Fair Employment and Housing, created some amendments at the end of the year in October. And so they had immediate effect. A couple of things that they did. One was expanded the definition of what's an applicant. So the Fair Chance Act applied to applicants for employment. And so they, I think, were seeking to close some sort of loopholes. So apparently, so now it includes individuals that began work prior to the employer reviewing their criminal history. So apparently there was some concern about employers that would hire someone and then review the criminal history and then make a decision about retaining that employment that didn't comport with the 2018 Fair Chance Act, but arguably that wouldn't have applied to an employee. It only applied at the time when the person was an applicant. So I think this was an attempt to close some sort of loophole that was maybe happening there. It clarified that the act applies even when selecting workers provided through labor contractors or union halls. And then it also clarified that that the act applies even to those employers that are required by some other law to conduct criminal checks. They said complying with such a law would not necessarily exempt them from the Fair Chance Act. So that's new employers. So if you're an employer in California that had taken the position that the Fair Chance Act didn't apply to you because some other law required you to do a background check and consider criminal history information, just know it's not necessarily an automatic exemption anymore, although it does still create a rebuttable defense. Again, if you're a California employer, if you've got people working in California, I highly recommend taking a relook at the 2018 Fair Chance Act. It was significant. There were a number of requirements under the Act for employers, and the Department of Fair Employment and Housing did create an FAQ on the topic. So I've got that link in there. If you haven't looked at it, look at it now. It's interesting, and I would say this is a significant update, at least for some employers. Hawaii, this is one we did talk about last time in November, so this is just an update. It did pass. It became effective in September of last year already. If those of you that follow this, that have been listening to me talk about ban the box for years, know Hawaii was one of the very first states that had a ban the box law. And so this amendment updates that law, and it limits employers' ability to consider criminal records based on the type of the record and also based on how old the record is. And so employers should be thinking about their policies and procedures and making sure that they are taking these new prohibitions into consideration. So 7-year limit on felonies, 5-year limit on misdemeanor convictions. Both of those timeframes exclude periods of incarceration. So it could bring you outside of the 7 years if there was sentence, or I should say, if there was actual jail or prison time. So be mindful of that and check your policies for that, especially if you are, for instance, asking the applicant to admit to criminal history. You might want to rephrase that question to limit that to only ask them about felony convictions that are 7 years and misdemeanor convictions of 5. Waterloo, Iowa, again, another one we talked about last time, but wanted to just give an update. It went into effect in July, mostly a reminder, I should say. City ordinance applies to public and private employers in the city of Waterloo where there are 15 or more employees. And very traditional, ban the box here. Employers can't inquire or require applicants to disclose arrest, conviction, pending charges during the application process up to or including the interview process. So be a little careful for your Waterloo, Iowa locations there. Illinois, another sort of big deal. This was passed by the Assembly in just earlier this year, so January. It is still pending signature by the governor, but do note it takes effect upon signature, and it's governor is expected to sign. Illinois also had an existing ban the box set of limitations. So it was part of their, it is part of their Human Rights Act. So that says employers may not ask applicants about their criminal history in the employment application. And with the new with the update that happened in January, employers will need to specifically show that their use of conviction records in the employment decision is related, where there's a substantial relationship between that record, between the record and some a substantial relationship between the criminal record and the duties and responsibilities of the job, or where the record presents an unreasonable risk to property or safety of an individual or the general public. So I would say employers be prepared to make and document those sorts of determinations. Employers were given a list of things to consider when looking for that substantial relationship. They're to do an analysis of the length of the time since the conviction, the number of convictions, the nature and severity of the offense, how that relates to the safety of others, facts and circumstances surrounding the conviction, age at time of conviction, evidence of rehabilitation efforts. For those of you that have been tracking this sort of legislation with me, this should sound familiar, right? These essentially codify the EEOC guidance related to an employer's consideration of criminal history information now into state statute, right? So what before was guidance from the EEOC, the state is now making part of a statute. And so not having this sort of analysis in place when you're considering a conviction record in your employment decision could subject you to a human rights or being accused of a human rights violation, right? So serious, something for employers to definitely be considering. So additional also pre-adverse notice requirements and a waiting period. So again, sort of implementing that individualized assessment process that the EEOC guidance was looking for, creating a way to communicate that, the decision related to that individualized assessment to the candidate so that they would have a chance to respond. And then if the employer does decide then to move forward with the adverse action based on the criminal history information, additional language that needs to be in that pre-adverse action notice. So the FCRA and Iowa pre and final adverse action, Illinois pre and final adverse action requirements still apply, right? So this is in addition to the FCRA requirements for pre and final notice. So Illinois employers are going to want to watch this and be prepared to get this implemented fairly quickly. As I said, scheduled to take effect upon signature. So be looking at timing around that. we'll hear more about this one, I think, as employers start to take it up. I would foresee some need, by the way, if Orangetree is helping you with your adverse action process, we should be talking about creating a separate set of adverse notification letters, and then making sure that the pre-adverse notice includes the additional information that's required by statute in that pre-adverse action letter. So more to come on that one for sure. Montgomery County, Maryland. So we did talk about this one last time. This is an update. So passed in November, became effective here in February, enacted their bill. Another county, another example, by the way, where ban the box, fair chance, decriminalization efforts change over time, right? So here's a locality that has had a regulation in place since 2014. This expands it, certainly following a trend that we are seeing over and over again. So in this case, note it applies to all employers with at least one employee in Montgomery County. Doesn't even have to be a full-time employee, and it's applicable to you as an employer. It excludes county employers that provide services to minors and vulnerable adults, and now prohibits inquiry into criminal history until after the conditional job offer. This one, by the way, different from one of the others I was talking about a minute ago, does actually provide an exception for that if there's some other federal or state law or local regulation that you're trying to comply with. Prohibits an employer from requiring an applicant to disclose arrests that didn't result in a conviction, and then also some first-time convictions for some from some types of criminal convictions. So trespass, disturbance of the peace, second-degree assault, misdemeanor convictions that are older than 3 years, or confidential or expunged records. Again, these are things employers prohibited from asking the applicant. So if you're an employer that asks the applicant to admit to criminal history in Montgomery County, be thinking about modifying the language of that. Well, obviously making sure you're only asking the question after a conditional offer, but then also be thinking about if you need to modify the question to limit that inquiry to misdemeanor convictions older than 3 years, telling them not to admit to some first-time convictions, and generally employers aren't asking about confidential or expunged records anyway, but something to think about. St. Louis, Missouri, another one that was sort of midway through the process when we talked in November. This one did pass. It went into effect here at the beginning of January. It's applicable to private employers with 10 or more employees. And the limitation, employers can't make an inquiry into applicant's history until after it's determined that he or she is qualified for the job and has interviewed the applicant. If the applicant's part of a final pool, the inquiry can only be made if it's made of everyone in the pool. I think that's just in the case where you're hiring directly from a pool and not as part of an interview. And employers can't base their hiring decision on the criminal history unless they can show how the history is relevant to the duties of the position. So again, one of those criteria from the EEOC guidance that's being codified here in this case into local law. Also limiting what employers can say about consideration of criminal history information as part of their advertising. So if you're advertising for a job, you want to keep notices about, that criminal history could preclude you from getting the position. You want to keep that out of any ads that you're doing. New York City, almost as complicated, maybe even more complicated than California when it comes to ban the box. Interaction between state law and the city ordinance or human rights Act. So New York City has had Ban the Box, Fair Chance Act in effect for a while. Already, the Fair Chance Act required an employer to do an individualized assessment. In that case, the individualized assessment had 8 factors that came from New York State law, Article 23. So they said if you were considering the applicant's criminal history as it related to a job, or if you believe that it would involve unreasonable risks to person or property to consider this person based on their criminal history, that you'd need to do the individualized assessment. It had already prohibited inquiries into criminal history before an offer of employment. And it required the employer to provide written notice of that Article 23A analysis, and also to provide time for the applicant to respond before the job offer could be withdrawn. So Article 23 factors, there were 8. The new FCA, the new amendment, has 7 different factors. So the new amendment says that the scope of the act is expanded to add new protections for applicants' employees with pending arrests and criminal accusations. So previously the FCA applied to employers' consideration of convictions. The new FCA expansion now also includes arrests and criminal accusations. That's the language that they use. So pending arrests and criminal accusations. So, and if an employer is going to use those, they have 7 factors. Some of them overlap, some of them do not. But now a 7-factor consideration around evaluating that pending or arrest or criminal accusation. So just to go through them quickly, the new 7 are that the New York City, the policy of New York City to overcome stigma towards the unnecessary exclusion of persons with criminal justice involvement in the area of licensure and employment. The employers to consider the specific duties and responsibilities necessary for the job, the bearing, if any, of the criminal offense or offenses to the fitness or ability of that person to do the job. The person was 25 years of age or younger at the time of the offense. New York City Council very concerned about excluding young individuals from the workforce, the seriousness of the offense, any legitimate interest of a public agency or private employer in protecting property, safety, welfare of specific individuals. Oh, sorry. I've been asked not to move my notes. I will try, but I really do need them. New York City is super complicated. I think I got to 6 and 7 was any additional information provided from the applicant. So note again, similar but not exactly the same as the Article 23A. Employers now have to solicit information from applicants and employees that are relevant to the factors. They have to provide at least 5 business days to respond to the notice of pre-adverse decision. It does allow for employers to place current employees on unpaid leave, doesn't specify for how long. It does clarify that employers can take adverse employment action if the applicant or employee is found to have made an intentional misrepresentation. So interesting there. And then there's additional notification requirements. So if you're going to revoke the conditional job offer, there's a 3-step process that employers need to take. Again, a lot to know about New York City employment. Importantly, I think effective date here is end of July, so we have a little bit of time, employers have a little bit of time to initiate or get processes in place. Applies, by the way, to employers with at least 4 employees nationwide, at least one of them working in New York City. So interesting application there. And then I do need to move my mic. Try not to put them so close to the mic. So New York City, spend some time on that if you have employees there. Suffolk County, New York, so another New York. This one also talked about it last time, so I won't spend too much time on it, but did go into effect in August of last year, applies to public and private employers with 15 or more employees, and it, nice traditional sort of easy one here, it prohibits employers from inquiring about a job applicant's criminal convictions during the application process or prior to the first interview. Philadelphia, this one, I'm saying it was signed in 2011, it was clearly 2021. But we do have a few months here for this one to take effect, so April 1st effective date. There was actually 2 bills that passed. The first one, the 4079, again, an update to the existing fair criminal record screening standards. So expands the definition of employee to any person employed or permitted to work at or for a private employer within the geographic boundaries of the city as an independent contractor, transportation network, company driver, rideshare driver, or other gig economy worker. It seems fairly clear to me that the intention here was to just ensure that gig workers were being included. Again, same, I think, point here with the expansion of the definition of what a private employer is. The Fair Criminal Records Screening Standard previously applied only to applicants, now applies to current employees. It expressly allows now inquiry into pending criminal charges under some circumstances. The other bill that passed in Philadelphia, March 21, 2021 effective date, relates to the ban on credit screening. So Philadelphia has had a limitation on employers' consideration of credit screening for some time now, and it allowed for some exceptions. And this just backs up those exceptions a little bit. They're not automatic exceptions. The employer has to sort of make a case for how the exception applies to their particular applicant. So significant change there in Philadelphia for Philadelphia employers to be taken a look at. Virginia, this went along with a marijuana drug testing change, but basically they decriminalized marijuana simple possession, so no longer a criminal offense. And just note, employers in Virginia prohibited from asking the applicant to admit to marijuana simple possession charges, arrest, or conviction. Again, this is one we talked about last time. I just throw it up here because it's been a little while, but it did go in effect here middle of the year in 2020. So that's what I have for ban the box, fair chance, decriminalization. Again, I would say the big ones employers should be thinking about spending time on: California, New York City. If you're in New York City, those are particularly interesting, different, harder, I would say, for employers. So spend time on those if you if they're applicable to you. Moving on then to some drug testing updates. I would say most of the action we saw around drug testing was at the end of the year last year because it was voter initiatives, right? So it was when you were all going to the polls. to do your voting. There were statewide initiatives that happened. Arizona is an example. They had Prop 207. They added recreational marijuana to an existing medical marijuana program. The proposition required a regulatory framework to be established here somewhat early in 2021. So there was an immediate effectiveness of the recreational marijuana program, but it's just not likely that anything will become available until that regulatory framework is in place. It made individuals 21 and older legal to possess, consume, or transfer marijuana, and it did have a few protections. At least it mentioned employer topics interesting for employers. It said employers aren't required to accommodate use, consumption, possession, transfer, display, transportation, sale, or cultivation in the workplace. An interesting question: what is the workplace in this time of working from home? But something that I'm sure will play out over time. Employers also aren't restricted in their ability to prohibit or regulate conduct permitted by Prop 207, so recreational marijuana, while on company property. So a couple of employer protections there built into the proposition. Driving while impaired, strictly prohibited by the proposition. Again, tough for police and courts to test for that. Washington, D.C., this was a voter initiative, in this case, a decriminalization effort. So it just designated non-commercial cultivation, distribution, possession, or use of entheogenic plants and fungi as the lowest law enforcement policies. So basically making it not a priority to track this distribution, cultivation, possession, use of magic mushrooms down. It does require approval by the DC Council, and the Council did reject a similar measure in 2018, and I have not seen that they have taken it up or rejected it or approved it yet. Interesting new trend. We hadn't previously been tracking decriminalization of, for instance, magic mushrooms. But now we are seeing, we understand that Denver, Oakland, California, Santa Cruz, California, Ann Arbor, Michigan may also be moving towards this or have some movement there. We'll talk more about decriminalization and delisting drugs from drug schedules when we get to Oregon, because that's a doozy. Mississippi, state of Mississippi, another voter initiative. So this is Initiative 65. This created a medical marijuana law, defined what debilitating conditions are covered by it within the law, and it allows for the program to be implemented by July 1st of 2021. Nothing in the statute or the initiative itself or the statute that's guidance for employers, but it does allow for rules and regulations to be implemented at the same time as the medical marijuana program is implemented in the state. So hopefully they will get some protections for employers written into those regulations. Montana, another voter initiative. There was two actually, 190 and 118. 118 made, this was recreational marijuana law, by the way. So people aged 21 and older are allowed to participate in the recreational marijuana market. And then Initiative 190 allows that employers are not required to permit or accommodate use of recreational marijuana in the workplace or on work property. And employers can take disciplinary or adverse action for violation of workplace drug and alcohol policies. They can, for instance, deny employment based on violation of the policy, for instance, a positive pre-employment drug test, and can also discipline employees working while intoxicated. That will be an interesting question here in New Jersey. is a good example of how that gets pretty complicated pretty quickly. So New Jersey, another voter initiative, public question 1, it was recreational marijuana law. The governor refused to sign it until there was some additional legislation. So this very long acronym is part of that additional legislation. But basically, what they have done in New Jersey is removed marijuana as a Schedule I drug. Legalized for adults over age 21, and then the effective date is complicated. So basically the section 87 of the law says that the provisions take effect immediately, but shall only become operative upon adoption of the Commission's rules and regulations in accordance with that section of the law. So there's some work to do there. And then those initial rules and regulations are to be issued within 180 days following the enactment of the law, or 45 days from the appointment of all 5 members of a regulatory commission, whichever is later. So my gut on that is it's going to take a little time for both of those things to happen. So we'll watch New Jersey, but I think employers do have a little bit of time to be thinking about this. I would say in the continuum of recreational marijuana laws that provide some protections to employers, this is on the other end of that continuum. It explicitly protects employees who engage in off-work marijuana use from adverse employment action taken on the basis of that use, and it limits an employer's ability to act on the basis of a positive marijuana test after employment has started. So it does say employers can still have a drug and alcohol-free workplace and maintain a policy about that, and that employers don't need to accommodate use, consumption, being under the influence, possession, transfer, display, transportation, sale, growth in the workplace. And employers can still have policies prohibiting use or intoxication during work hours. A tough law, though, for New Jersey employers, and I would expect to see at least some employers reconsidering marijuana drug testing. If not reconsidering it, certainly it's a time to be looking at your policy to make sure that it is within what is allowed under the new recreational marijuana law in New Jersey. Oregon, I mentioned before, decriminalization, delisting efforts. This is very much a decriminalization effort. What they've done is there's 2 measures that passed. I'm skipping right to the second one, but basically Measure 110 classifies possession of a Schedule 1 through 4 controlled substance as a violation that may result in a fine, or in lieu of a fine, a completed health assessment. So possession now of Schedule 1 through 4 controlled substances that might have before been subject to arrest, imprisonment, certainly would have been criminal in nature, decriminalized. So the health assessment that is called for or allowed needs to be done through an addiction recovery center and include a substance use disorder screening. And that went into effect here in February 2021. So Oregon employers be thinking about, this is decriminalization, right? So maybe not a direct correlation to employment, but something to be thinking about for Oregon employers is drug testing for scheduled controlled substances might become a little tougher for you to make employment decisions based on that. I think I have 5 minutes here and I'm I'm pretty close. South Dakota, another voter initiative. This one was historic in that it was one initiative for both medical marijuana and recreational marijuana. The medical marijuana program will go into effect here in October 2021. It includes physician certified debilitating conditions. It does have some protections for employers. Participants are prohibited from undertaking tasks under the influence of cannabis. When doing so would constitute negligence or professional malpractice. And employers aren't required to permit ingestion in the workplace or employees working under the influence. So that's helpful for employers. You know how I said it was first in the country that had included both medical and recreational marijuana on the same voter initiative? Well, recently, this week, in fact, I think we had court judge ruled that it was unconstitutional, that violated state requirements that restrict voter initiative measures to a single topic. So expect that to be challenged here in the coming months. We're tracking a lot of these. I expect more of them will pass. Really, voter initiatives seem to have worked really well. I expect that to continue to happen, and then usually followed by some sort of modifying or enhancing or regulating legislation. These are the things that we look for. I only have about 4 minutes, so I'm going to keep going. Slightly different topics here. Just wanted to bring your attention to Virginia. Became the second state in the nation to pass privacy legislation. So a few years ago we had California. It is still pending signature by the governor, but it's expected to happen sometime after March 1st, after the legislative session happens. 2023 effective date. Interestingly, not that similar to the California privacy statutes. It's very much intended to regulate data processors, data controllers, has some number of records or number of consumers in the system or that you process data about in order for it to be applicable. I don't see that it contemplates employment data, so I think that's fairly good news for employers. It just outlines privacy and protection standards for controllers and processors, as you might expect. Gives consumers some rights around access, correcting, deleting, obtaining a copy, and opting out for some advertising requirements. No private right of action. So this will be a few years working its way into systems. I expect there will be regulation that will go along with it when it's implemented, but second of its kind in the country. So I wanted to just mention it quick. And then my last two topics here deal with the Fair Credit Reporting Act. We had what I think is great news for employers. The Consumer Financial Protection Bureau in January made a recommendation to Congress to amend the Fair Credit Reporting Act to impose limits on class action lawsuit monetary awards. Great news. Unfortunately, very end of the last administration, I think we'll all be surprised if the current 2021 Congress is actually able to move on this or makes any progress on it, but we'll keep an eye on it. And then I had just mentioned really early in the conversation, the Ramirez v. TransUnion case, a Supreme Court opinion expected on this one here in the coming year. It's really about, again, with Fair Credit Reporting Act, if you've been to any of my sessions, tends to, the questions are about Article 3 standing, whether there was actual harm or damages. And in this case, an issue of when certifying a class, are the damages of the majority of the class, do they need to be similar to the named party of the class? So we'll see how that turns out, and hopefully I'll have another update for you on this one next quarter. And I'm sorry, Renew and Jeff, I think I've gone right up to the the last minute, but if there's a quick question, I can probably do it.
Well, we're going to try. So we have a question that goes like this. Our a little bit of context for in the combination. Are employers still allowed to take jail and prison time into consideration? Because if a candidate had an older conviction, let's say a 2010 date of an offense, but served, say, 7 years and was released in 2017, is that a record that the employer would be able to take into consideration?
Okay, so that's a kind of complicated question, but let me try to give you a 1-minute answer. Federal law, Federal Fair Credit Reporting Act, says consumer reporting agencies can report criminal convictions no matter how old they are. That is not the case for non-convictions, right? But we're talking about a conviction that actually happened. Somebody was sentenced, they did time, can be reported regardless of age, right? Layer on top of that state law limitations. There certainly are states that limit how far back you can look, and states also legislate and limit what you can count within the time frame. So the answer to the question is it depends, and it depends on what state you're in. And then layer on top of that EEOC guidance, which may or may not be now codified in state statute as well, that says employers should be taking into consideration how long it's been since the offense and what the rehabilitation efforts have been in their use of criminal history information. So EEOC guidance would say the older the record is, the less likely it pertains to the duties and responsibilities of the job, or the less likely there's a nexus between the job and the interaction that person's having with the public, or some concern about keeping the public or other employees safe. So unfortunately, my answer is it depends. But if there's a particular state that they're in or thinking about, I think that's where, with the context of EEOC and FCRA and the background, I would focus in on what the state law requirement is or limitation is.
Thank you, Heidi. One more. There is an employer in Ohio. They have a felony question on an application, their application. Occasionally, this employer finds hiring sales reps in some of the states that have banned the box limitations. Would we fall under the state-specific ban the box limitation?
Yeah, unfortunately, again, depends. So it depends on how that local regulation or state statute or ordinance is drafted, right? So sometimes they talk about where the employee is working. Sometimes they talk about where the employer is. Sometimes it's a consumer protection law, and so it has to do with where the consumer is. So a real conservative approach would be don't ask the question, right? EEOC guidance would say, hey, employers, consider not asking the question about criminal history at all. And then the other slightly less conservative, but still pretty conservative, would just be take a really long view about ban the box, and just wait to ask the question. If you want to ask the question, wait to ask the question until post-hire or post-conditional job offer.
That's a hard one.
Pardon me?
A lot of things you got to look at there.
Yeah.
A lot of things you got to look at. Heidi, thank you very much. A lot of content in a short period of time. We appreciate your expertise. For everyone on the call, there'll be an email with a link to a replay. Handout will be available. If you have questions, you're thinking about today's webinar and some of the content, you have additional questions, reach out to, if your client care specialist, reach out to myself. My contact information is in the handout, and there will be information also. There's a couple of questions on SHRM credits, different type of credits. That information will be also made available to everyone. So thank you for attending our first quarter compliance update call today with Orangetree. Have a great day.
Thank you.